Hello everyone. In this video, I will discuss a very current issue in Indonesia's digital space. The government's crackdown on online gambling platforms. Since late 2024, the Ministry of Communication and Digital or Komdigi has ordered thousands of online platforms to sign an anti-online gambling integrity pact and has blocked more than 1.3 million gambling contents on websites and social media. Here, the policy will be analyzed using Hukum Administrasi Negara, and the focus is whether this policy can be seen as Keputusan Tata Usaha Negara, how it applies asas-asas hukum pemerintahan yang baik, what legal remedies are available, and what governance improvement can be recommended. First, let's look the basic facts. On 27 August 2024, Komdigi announced an ultimatum to around 18,000 private electronic system providers or PSE. These providers must complete an integrity pact against online gambling in the PSE registration system. The idea is that platforms commit to prevent, detect, and remove gambling content on their service. If they fail to sign or comply, Komdigi can impose administrative sanctions, including blocking access to their system and revoking their registrations. This ultimatum is connected to Government Regulation Number 71 of 2019 on Electronic System and Transactions and Ministerial Regulation Number 5 of 2020 on Private Electronic System Providers. Both regulations require private PSEs to register and allow the government to cut access when obligations are ignored. Later, in press release on 2 May 2025, Komdigi reported that from 20 October 2024 to 20 April 2025, they had handled more 1 million online gambling contents. This includes over 1.19 million gambling websites and around 127,000 social media contents. Komdigi also launched Saman, Sistem Kepatuhan Moderasi Konten, which forced platforms to remove high-risk content within 4 hours and other negative content within 24 hours. From the perspective of Hukum Administrasi Negara, the first question is, are these actions administrative decisions or Keputusan Tata Usaha Negara? In general, a KTUN is a written decision issued by an administrative authority based on public law, is concrete, individual, and final, and which creates legal consequence for a person or legal entity. Komdigi, through the Minister of Communication and Digital, clearly acts as administrative authority. When the minister ordered PSE to sign the integrity pact and threatened them with blocking or revocation of registrations, this is already a form of public law actions. When Komdigi actually decides to block access to a particular platform or cancel its PSE registrations, the decision is directed at the specific provider. It's final administrative process, and it changes the provider's legal positions. Therefore, each act of blocking or revocations can be qualified as a KTUN. That means these acts can become objects of dispute at the administrative court, Pengadilan Tata Usaha Negara. Formally, Komdigi justifies its power based on several norms. Article 28G, paragraph 2 of the 1945 Constitution allows right to be limited by law to protect public order, morality, and the rights of others. Government Regulations Number 71 of 2019 and Ministerial Regulations Number 5 of 2020 give the minister authority to regulate PSE registration and to impose administrative sanctions, including access terminations. So, on paper, and the minister has the legal competence to act, but administrative law doesn't stop at legality. It also asks whether the power is used according to general principle of good governance. Next, the policy must be examined using Asas-Asas Umum Pemerintahan yang Baik, AAUPB. The first is Asas Kepastian Hukum, legal certainty. Komdigi already used clear regulations like PP 71 2019 and Regulation 5 2020 as its legal basis, which is positive. However, legal certainty is not only about having regulations, but also about clarity of criteria and predictability. In this case, we can ask, are the definitions online gambling content and non-compliant PSE explained in enough detail? If the standards are too general, platforms may feel uncertain and fear that legal content or minor mistakes could lead to heavy sanctions. The second is asas keterbukaan, transparency. Komdigi has published number of blog contents and explains its cooperations with BPK. This is a good practice, but openness should also appear at the individual level. When a specific platform is blocked, it should receive clear written notifications, reasons, and information about how to challenge or correct the decisions. Users should also know that a service is blocked because of an official administrative decision, not just a technical error. The third is asas proporsionalitas dan keadilan, proportionality and fairness. The intention to protect society and children from online gambling is legitimate and important, but sanctions must be proportional to the violations. For example, immediately revoking a PSE's registrations may be too extreme if the platform is trying to comply but has limited technical capacity. A more proportional approach would combine warning, deadlines for improvement, temporary restrictions, and only as a last resort, full revocations. If the steps are not gradual, the campaign against gambling can look strong, but risk being unfair to smaller or good faith actors. Strong administrative actions must always be balanced with legal remedies. First, there is possibility of administrative objections. A PSE whose access is blocked or whose registration is revoked should be able to send an objection or clarification to Komdigi. The ministry can reassess whether the decision was correct and whether the platform has already fixed the problem. Second, if in the process there are indications of maladministration, for example, no prior notice, unclear reasons, or long delays in handling complaints, the PSE or users can submit a complaint to the Ombudsman of the Republic of Indonesia. The Ombudsman can investigate and issue recommendations to improve administrative procedures and enforce AAUPB. Because blocking and revocation qualify as Keputusan Tata Usaha Negara, they can be challenged in the administrative court. The court can examine whether the minister's decision is within his authority, follows the procedures in the law on administrative governance, and respects AAUPB. If the issue lies in the regulation itself, there is also room for judicial review at the Supreme Court or the Constitutional Court, depending on the level of the norm being challenged. Based on this analysis, there are at least three recommendations for better governance. First, Komdigi should develop and publish detailed public guidelines on how online gambling content is defined, how it's detected, and how its PSE compliance is evaluated. This will strengthen legal certainty and reduce the feeling of arbitrariness. Second, there needs to be a simple, transparent, and fast complaint mechanism, both for PSE and for users. Platforms that feel wrongly blocked and users who cannot access a lawful service should know where to complain, what the steps are, and how long they have to wait for response. Third, the government's cooperations with BPK and law enforcement agencies should be complemented by regular dialogue with civil society, digital rights organizations, and academics. This will help ensure that the fight against online gambling remains effective while still respecting administrative law principles and rights of citizens in the digital era. To conclude, the crackdown on online gambling platform shows how powerful administrative decisions can reshape our digital environment. At the same time, it reminds us that very exercise of state power must be controlled by law and by asas-asas umum pemerintahan yang baik. So, that's the protection of the public doesn't become arbitrary or unfair.